You are now listening to the Fighting Back Podcast, and here's your host, Jessica Travis. Welcome back to a brand new episode of the Fighting Back Podcast. I'm Patricia, and I'm sitting down here with attorney Jessica Travis. Jessica, how you doing?
Good. What's up?
I am battling a cold right now, and I hope I beat it. How about you?
I feel like that is going around. Everybody has gotten sick in the office. I see judges are canceling courts and dockets getting sick. Like, this is the time when people are just like, that cold to warm weather, and Florida can't make up its mind as to what it wants to be.
Oh, yeah, no, it's and it's funny because like earlier today, it was gray. It was gloomy and gray, and now the birds are chirping, the sun is out, and I'm ready. Hey, I got some questions for you. You ready to do this?
Okay.
All right, so today we're going to be talking about child support modification, and we got some questions from the listeners, and I'm going to throw them at you. So let's start with the first one.
Okay, I'm ready.
Boom, 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 and here it is. When someone says they want to modify child support, what does that legally mean?
Well, child support is an order. It's an order that comes from the judge that says this person needs to pay the other person this amount of money. So whenever you want to modify child support, that really means legally getting a new order from the judge saying now this person has to pay this other person this amount of money.
And usually, I mean, does that come with like a timeline? Does it expire or it just...
Yeah, so child support usually comes with a timeline. It usually starts when the judge orders child support, or it can start at an earlier date depending on when the judge wants it to be. So it can be retroactive to when you file the petition or something like that.
Okay.
And it lasts until it's A, modified by the court, so the court issues a new order, or the child turns 18, or is still in school at the age of 19 and finishes high school, or the child is a dependent adult.
Okay. So basically, it depends when it comes to the end of child support.
I mean, the law is always, it depends, but usually child support ends when the child turns 18.
Okay, cool. So here is our next question coming in. Is child support automatically adjusted over time, or does someone have to file something?
That's a really good question, because a lot of people think that child support automatically goes up with inflation or is adjusted for cost of living, like a lot of other things that we have. But it's not. So child support amount is a specific amount, and it's the amount that is ordered, and it stays the same unless the court changes the amount. So
Okay.
It doesn't get automatically changed or automatically adjusted.
What would cause like a change?
Well, in order for there to be a change in child support, there has to be a substantial change in the financial circumstances of the parents.
I feel like you just looked at my questions because like that was going to be the next one. Like what qualifies as a substantial change under Florida law?
So the child support guidelines, the substantial change for a modification to occur needs to be at least 15% change or $50 change, whichever is greater. That constitutes a substantial change in circumstances for a modification to occur. For the Department of Revenue cases, it's a little lower. It's about 10% of a guideline change or a 25% difference.
Okay, well, good to know right there. So next question coming in, what are some myths about modifying child support?
Yeah, I think we touched on a few of them. So one of the myths is that child support is automatically modified. Not the case. You have to go in, you have to ask for the judge to order it. The second thing is, one of the myths is that child support is automatically modified when you file the request or the petition for modification of child support. That is not correct. So that petition to modify child support is asking the judge to modify it. But nothing becomes final until and unless the judge issues an order modifying your child support.
So you could file a motion. I mean, you could file a motion or a petition to modify, and nothing's going to happen until the judge says, okay, we're good to go.
Correct. Only when you get the judge's order modifying child support, that's when it actually becomes official and the modification takes effect.
So there are a lot of steps moving forward to get this done.
Absolutely.
All right. Next one coming in. This one's a little tricky. Can someone just say, I can't afford this anymore?
No. No.
Let me ask that one more time. And I want to hear that answer one more time.
Yeah.
Can someone just say, I can't afford this anymore?
So No, I would not recommend that anybody who is ordered to pay child support just not pay child support. So the court system's set up so that if child support is ordered, the court really does want that person to pay, right?
Yeah.
To support the child, for the good of society, all of those things. So because of that, the courts have set up many means to enforce a person paying child support. So did you know if you don't pay child support and it's ordered, you can have your driver's license suspended.
Ooh.
You could have your wages garnished.
Oh.
You could have your bank accounts garnished, and the judge could actually put you in jail for not paying child support and not let you out of jail until you pay a certain amount of your child support.
I can hear a lot of baby mamas just like, yeah, put them in jail, lock them up, kind of thing.
I mean, it's counterintuitive because if you're in jail, you're not making money to pay child support.
Exactly.
So you need to be out of jail to make the money to pay the child support. But if you don't pay the child support, you could go into jail as a result. So I would, again, recommend pay your child support if you can. Mm-hmm. If you can't, go talk to the judge about why you can't and try to get it modified.
Okay. So, yeah, I've actually heard over the years people trying the craziest stuff to not get out of paying child support. And one question coming in, if someone voluntarily quits their job, can they lower their support?
So that's a good question. And the answer is usually no. So voluntary unemployment. So somebody chooses to quit their job, chooses not to be employed, chooses not to go get another job. Mm-hmm. That is typically not a basis to reduce or eliminate your child support obligation.
Because like it's like an intention of not wanting to pay.
Correct. It's the intentional not having a job, not paying. Now, if somebody involuntarily loses their job or is trying to seek employment and cannot for some reason get employment or be employed or can't find a job, that can count for a reduction or an elimination of child support.
Okay. So along that, like I've heard horror stories over the years working in family law of people not disclosing all their financials to pay less child support. And this question kind of reflects on that. What if someone is intentionally earning less? Like what can be done at that point?
Yeah, so we can do something called imputing income. And so what that is that the court's going to look at somebody's incomes, look at what somebody is actually making. Mm-hmm. They're also going to look at what somebody can be making, right? So we take, for example, somebody who is a CEO at a company and is making hundreds of thousands of dollars as a professional, has these degrees, like is making a lot of money. And then they decide, you know what? I'm going to go work at a grocery store as a bag boy. And then they say, well, Judge, I have to have my child support reduced or eliminated because I'm only making minimum wage at the grocery store. The court's going to look at that and say, you know what? You could be a CEO, you could be making hundreds of thousands of dollars because you did in the past, and you have that experience and you have those qualifications, and there's really nothing stopping you from being able to make that kind of money. So we're going to impute, or we're going to say that you are making that money even when you're not, for purposes of calculating child support.
Wow.
Right?
Okay.
Yeah.
So you're still going to have to pay it regardless.
You're still going to have to pay it. Even if you are not making the money, if the court finds all of the basis to impute your income, you could still have to pay that high child support, even if you had lost your job for whatever reason.
So basically, at the end of the day, there's really no way of getting out of it.
There's really no way of getting out of child support. It really is something where the law is set up where if you have a child, the law expects you and will do everything that it can to require that you support your child.
So I feel that you probably go through this a lot. People always asking you legal questions, people wanting to get legal advice from you in one way or another. And all my friends know I work at a law firm, and I never give legal advice. I'm like, call our office, set up a consultation, and you'll get the answers you need. But like, here's one that I hear all the time. What if someone gets a big raise? Can the other parent ask for more?
So modification works both ways.
Okay.
You can ask the court to reduce your child support obligation if you lose your job or if you're making less money, but you can also ask the court to raise the other person's child support obligation if that other person has a significant increase in an income in any of those things. It has to be a consistent, right? It can't be like a one-time bonus or something like that. But like a significant raise, if there's a change of at least 15% or $50, depending on which way it goes, up or down, that can be a basis to modify.
So this is a really odd question. I'm asking this as a hypothetical. So let's say, for example, I'm paying child support and I just got promoted. I got a big raise. Everything's going perfectly, but I don't really say anything about that. Am I obligated to report that to the court that I'm now making more money?
So a lot of it's going to be based on what your final judgment said.
Okay.
What the child support order said, what your final judgment of either paternity or dissolution of marriage or whatever it is that made the child support order happen in the first place. What that says. Sometimes the courts do require that financial disclosure, sometimes they don't. But if a person files a petition to modify the child support, so say, for example, the person that you're paying child support to gets a whiff of, I know Rocky just got that big raise. I bet he's making way more money now. He just posted on Instagram that he has this new raise and he's got this corner office and he is just living large. They can file the petition to increase child support. And then at that point, you will be required to do disclosures.
Ooh.
So you will be required to give the other person bank statements and financial records and W-2s and pay stubs.
All of it.
All of it in order to show whether or not you are making more money.
Hence the term mandatory disclosure.
Because it's mandatory.
All right, so we have time for one more question, and the question is: does a change in time sharing automatically change support?
So it's not automatic, and none of this really is an automatic change. But yes, if there is if there is one person's failure to exercise court-ordered time sharing. So if you have a time sharing schedule, you have a parenting plan where each person is ordered a certain amount of time sharing, and one of the parents chooses not to exercise that court-ordered time sharing, that can be deemed a substantial change in circumstances in order to have a support modification.
Ooh. All right, so basically from all that information, one, you can't get out of child support.
Right.
You're going to have to pay your child support.
If it's ordered, yes.
Do not pay your child support.
Correct. Yep. All of those things, yes.
Is there any final thoughts you want to give the listeners before we wrap this one up?
So in law, really, the answer is always it depends. And so all of these modifications or changes in child support calculations are really based on individual income, the parties, the time sharing, everything involved. So each case really is different. And while we can give some general overviews about the law, I really recommend that if people have questions about their specific case, to call so that we can really, or email, so that we can dive into really their specific facts of the case and figure out the best thing for them.
Love that. And if you have questions in regards to a question for the show for Jessica to answer, you can send your questions over to help@fighterlaw.com. We review those on a weekly basis and make sure they are good to go for the podcast. With that being said, my name is Patricio, a.k.a. Rocky. Jessica, thank you so much for your time and knowledge, and we will see you later. Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fight It Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fight It Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.